You, Don. Okay, so like Don said, my name's Amanda Winalda. I'm an executive attorney at Anderson Advisors. So I know a lot of you probably have heard of Anderson. We do tax and asset protection, set up legal entities, do tax planning. I specifically run the land trust and deed department. So I did a presentation on how you can use land trusts in your investing. It's actually become really popular in recent years with subject to deals and with countering that due on sale clause with interest rates having shot up in the last year or so. But what I also got him put in charge of is the Corporate Transparency Act. And this has been a hot topic for probably the last 6 months, but it has really revved up in the new year. And it's not hard to see why. It's very confusing. It's new. It's really groundbreaking legislation and sort of government oversight. So we will go through exactly what the Corporate Transparency Act is, what you have to file, the pieces of information you need, the penalties for not filing, and then we'll also go through a few examples. So depending on what your asset protection structure looks like or what your business structure looks like, whose information you have to file. And then finally, we'll go over what you can do now to get prepared for your filing and what you need to do with your corporate documents to get set up to really move forward with this law that, quite frankly, isn't going to go away. All right. So what is the big overview? The Corporate Transparency Act, or what we're going to call it the CTA for short, it's a federal law and it went into effect January 1 of this year. And it requires business entities to report what's known as their beneficial owners. And I'll go into a lot more detail as to what a beneficial owner is. The purpose, as they say, is to combat terrorism, money laundering, all kinds of illicit activities. Most people are seeing that it's really just becoming this huge burden on the small business owner. A lot of people think it's government oversight. You can go ahead and throw into the chat if you want your opinion. Government big brother, or do you think this law is actually going to shake down as it's intended? That's a big point of contention. Regardless, we have to comply with it if we want to run our businesses in this country. But who knows? They caught Al Capone on tax evasion. So, hey, maybe we'll catch someone, right? All right. So here's the nitty gritty. And there's a lot of information here. So feel free to take a screenshot and we can go over more details with the Q&A. But what you have to file with FinCEN. So all of these reports for the CTA are going through FinCEN, which is the Financial Enforcement Crimes Network of the U.S. Department of Treasury. Entities that are formed January 1 of this year on to the end of this year have 90 days from the date of formation to do this report. Entities formed January 1, 2025 have 30 days to file the report. So this timeline actually moved about 3 times in the last 4 months. They originally was only giving people 14 days to file. Then they gave 30 days to file. And finally, in mid-December, they extended that deadline to 90 days. It's been a little bit hard on the compliance side to build our systems with that target moving, but it's good that they've given us 90 days because that gives you more time in this first year as people are figuring out how to file these reports, as even FinCEN is figuring out how they're going to be processing the reports. The act went into effect January 1. If you had looked at the FinCEN website on December 31st, you would not have even been able to see a sample of the report. So everything really just January 1, the clock hit 12 a.m. and it was a free for all. So we do have 90 days for any entity that's created this year, and then ongoing entities reports will be due within 30 days. If you have an existing entity that was formed prior to this year, we actually have an entire year to file those reports. And that's because obviously that's going to include every business that has been created up until January 1. So we're giving themselves and the public a lot of time to understand this rule, understand the law, collect information, potentially have to get a lot of information from a lot of different people, seek legal counsel, those types of things. So we have an entire year for any pre-existing entity. If there's any change to this information for the reporting company, the beneficial owner, then you do have to file an updated report, and that deadline is going to be 30 days. So depending on when your business started and when you're making changes to it, you're looking at a 90-day deadline, a 30-day deadline, or the end of this year. So what exactly are we reporting? So any entity is going to be deemed a reporting company. That's the official terminology, a reporting company. And what the reporting company has to include on this report is its legal name, any trade names and DBAs. So if you go out and you say, oh, my company A is doing business as Donald Duck LLC, then you have to include that as well. A complete US address. So if it's a foreign formed entity, you need to have a US based address. And then the state of formation. The state of formation can be any of the 50 states, a US territory, maybe a native territory, native tribe territory. Wherever your entity was first formed, that is the jurisdiction that you're going to be listing. And then the tax ID number or an EIN. Pretty easy peasy for your company. That's most likely going to be right there on your filed articles. If not, right there on the first page of your operating agreement. It should be pretty easy to find that. Beneficial owners and company applicants are a little bit more difficult. So for each of these two types of people, you need the full legal name. So if you go by a nickname, you need to include your full legal name, not your nickname. If you have junior, senior, some kind of suffix at the end of your name, you need to include that. Full legal name. If you've got 3 middle names, you need to include all of them. So it can't be an AKA. It needs to be what's on your official identification documents. Your date of birth, that's obviously never going to change, so we don't need to worry about that. And then a complete current address. If you don't want to give your address, if you want to use a PO box, unfortunately, you have to use a US address. If you split time between 2 different places, you need to pick one. So we are advising clients to use the address that they consider their primary residence or their tax home. For most of us, that's pretty straightforward. We live in one place. We're giving that address. But for people who split time in different places, or if you're maybe a digital nomad, then even the question of your address can be a little bit more complicated. And then finally, your government issued photo ID. They don't just need the information from the ID, such as the state, the unique identifying number. They also need a picture of it. So you're going to need to scan that. JPEG and PDF version seem to be what the online reporting software will accept. So no other kind of version, you need to convert it to a JPEG or a PDF. And we are collecting on our end, the front and a back for that. So government issued ID is going to be obviously a passport, driver's license. Those are preferred. We've had the question come through of whether you can use a military ID. That is government issued, so we can try using that. There isn't any specific guidelines saying, no, that's not allowed or not, but we really want to be collecting either a driver's license or a passport from you. And then that's going to be for beneficial owners and also company applicants. And then finally, this FinCEN ID. So they've come up with this opportunity where if you're setting up multiple entities, with Anderson, we've got clients who come to us and set up 10 LLCs all at once. Instead of providing all 4 pieces of information, your name, your date of birth, your address, your government ID, for each and every one of those reports, you can actually go to the FinCEN website and apply for a FinCEN identifier. And what that's going to do, it's going to require you to create an account, similar to how you create an IRS account to pay your taxes, but you'll be creating an account. You'll upload this information one time and it'll spit out a random number, kind of like a social security number or an EIN number. I believe it's 10 digits. And then you can put that on every one of your reports rather than filling it out with all of those previous informations. The FinCEN identifier is a point of contention because you do have to keep the information associated with that ID up to date. So if you get married and change your name, or if you get divorced and change your name, if you move to a different address, if you get a new ID, if your ID expires and you have to take a new picture and you have a new ID, all of those things require you to update your information with FinCEN. So if you have a FinCEN identifier, you can just update the info as it's associated with the ID. If you don't have a FinCEN identifier, then you need to update it on all of the reports for all of your entities. The downside, that sounds like it makes things a lot easier. However, there currently is not a process to cancel a FinCEN ID. So theoretically, you could be 95 and moving into a nursing home, and because your address is changing, you'd have to go and update your FinCEN ID. A lot of people believe that as more and more regulations and rules come out associated with the CTA, that FinCEN will develop a way for you to cancel your ID when you no longer own any businesses. But right now, if you obtain a FinCEN identifier, do so with the knowledge that there may not be a way to cancel it, and you'll be updating that information for life. Sounds fun, right? The whole thing sounds fun. It's been very much a moving target. Things, like I said, even the just deadline for reporting changed in December. So we're moving. We have to be a little bit flexible in what we're doing. Recommendations are changing, but right now it's kind of up to you if you want to get the FinCEN identifier. It's best if you obtain that yourself, because it does require creating an account that's going to have a password associated with it. So if you're having us do your beneficial owner report, we don't necessarily want to create that account for you and be responsible for creating that password and having that. You want to be able to do that yourself. So that's a great one if you're looking for an action item that you can do now. Obtaining that FinCEN ID is one of those. All right, so definition time. We saw what information each reporting company had to provide, a beneficial owner, company applicant. So now what are those? So a reporting company is basically any entity that has been created in the United States or is registered to do business in the United States. So if it's foreign and it's coming in and it's registering in the United States to do business, it's going to be a reporting company. All entities are reporting companies to start with. And then there's a list of 23 exemptions that potentially pulls your business out of the group of entities that have to report. 23 exemptions. The long list is here in green. Most of them are industries that are already heavily regulated. So the information that the CTA requires, they're already reporting that to some branch of the federal government. Securities, that information is already going to the SEC. Banks, insurance companies, things like that. There's a couple of, out of this list, there's a few that most like small business owners, regular people in America are going to fall under. Number one is going to be a nonprofit. We set up a lot of nonprofits. Any nonprofit or 501c3 charity and any of its subsidiaries is going to fall under exemption number 19 for a tax exempt entity, and it's not going to be a reporting company, so it doesn't have to file. You don't have to file an initial report. You don't have to update anything. You don't even have to file a report to claim the exemption. You just don't file at all. So if you need to talk to somebody, you want to talk to a legal professional to make sure that you fall within the exemption, because if you just think you fall in the exemption and don't report, you could get dinged for failure to report if you actually don't. The other exemption is for large companies. And a large company is defined as any company that has 20 or more full-time employees. That's not a ton of employees, so that encompasses quite a few businesses out there. That's why this exemption is really the reason why the small business owner feels attacked by this legislation, right? Because 20 full-time employees is not a lot. So you're talking huge companies like Amazon, Tesla, Walmart, they're not having to file this beneficial ownership report. Full-time is going to be determined on a state-by-state law basis. So that can be as little as 34 hours in some states. And so you really have to look at where your state's located if you've got that 20 full-time employees. And then any entities that are considered unfiled. So we set up a lot of land trusts, personal property trusts, series cells. Those types of entities, they're not created by filing documents with a state, with the Secretary of State. So they're not even considered a reporting company. A land trust would not have to report. However, something like a Delaware statutory trust or a Wyoming statutory trust, those are business trusts and they are created by filing documents with the state. So those types of trusts do have to file one of these reports. So the last exemption, which seems like it would be very straightforward, but is actually not at all, because why would they make this law simple, is number 23, the inactive entity. A lot of clients are coming in at the end of last year saying, hey, I've got this LLC. It's not really doing much. If I dissolve it, do I have to still file a beneficial ownership report? And unfortunately, the answer might be yes. Just because your entity is dissolved does not mean it doesn't have to report. There's actually a 6-part test for the inactive entity exemption. 5 of the 6 parts are very straightforward. Does it hold any assets? No. Great. Has it not changed ownership in the last year? Has it not sent or received up to $1,000? Those are all really easy to say yes to if your entity's been dissolved or if it's just been sitting there kind of dormant. But if your entity has any ownership by a foreign person, it does not qualify for this exemption and it must report. And if your entity was in existence before January 1, 2020, it does not qualify for this. If it wasn't in existence before January 1, 2020, it does not qualify for this exemption. So let's draw a line at January 1, 2020. If your entity was created before that and it hasn't done any business, it's not owned by a foreign person, it hasn't received or sent $1,000, and it doesn't own any assets, then it's exempt under this inactive entity exemption. However, if your business was started January 1, 2020 on, then it doesn't meet that first part of the test. So even if you set up a business January 1, 2020, and COVID hits, and it just doesn't work out, and you closed it in 2022, that entity will still have to file a beneficial owner report. It seems like a completely illogical result, but that's the way that the rule is written, and there hasn't been any subsequent legislation or subsequent guidance by FinCEN to counter that, to make that rule kind of make more sense. And when you look at the purpose of the law, it actually does make sense because the purpose is to collect as much information as possible. So they're basically saying, we're collecting all this info for any entity that's still doing business. And then for these businesses that were formed in the last 3 years, we just want everyone's info. Doesn't matter if it's closed, doesn't matter if it's not doing any business. We just want all of the info. So that's a little bit of a confusing one, I know, but if you've started your business anytime after 2020, then you do have to file that initial report. If you subsequently close the entity, dissolve it, you potentially don't have to file any updated report because it's not doing anything, but you will have to at least file that initial report. All right, so what is a beneficial owner? Beneficial.
Amanda, can I interrupt you for a second?
Yeah.
Students, we're getting a lot of questions, and please let her answer the questions before you throw them out, because what's going to happen when we get to your questions at the end, we're going to go, oh, we've answered that, we've answered this, we've just give her a minute, let it get through the presentation, write down pen and paper, write down your questions, we will get to them, but let her teach in sequential manner, and I think she'll get to most of them. Okay, sorry about that.
No,
Thank
it's
you.
okay. Thank you. Yeah, I know I'm explaining this inactive entity exemption. I'm just thinking of all the people who have called in and say, okay, this is my situation. Does it qualify? And I know there's going to be a ton of questions and we will leave a ton of time at the end. But let's get through the basics. So a beneficial owner is essentially the ultimate owner of your entity. So there's 2 tests. It's somebody who owns 25% or more of the ownership interests, or it's somebody who exercises substantial control. So think if you've got an LLC, it's going to be the members, any member who owns 25% or more. It's going to be the managers, the ones who conduct daily business. For a lot of our clients, those are the same people, easy peasy. But let's say you've got a larger company and you've got shareholders who own 25% or more, those are going to be beneficial owners. But you've also hired a president or a CEO that doesn't necessarily own 25% stock. Well, those president, CEO, they're still going to be beneficial owners because they exercise substantial control over the reporting company. And so we're going to actually go over a couple of 3 examples. They'll start very simple and then go into more complex. And you can see how it can be a little difficult to figure out who it is. People who potentially are 25% owners but do not qualify as a beneficial owner are going to be a minor child. So we have a lot of clients who will open an entity and name their child as an ownership so that they can get some of the income coming through at the lower tax bracket. It's a tax strategy. The minor child is not going to have to report their own information. Instead, you report the parent's information or the guardian's information as a beneficial owner. Once that minor child turns 18, then you have to file an updated report to put that individual's information onto the company. Nominees, intermediaries, custodians, and agents are not considered beneficial owners. So for example, when we do a trust, a statutory trust, Clint, our partner Clint, will often serve as a nominee trustee because he's simply there as a placeholder. He's not exercising any actual control. He's not considered a beneficial owner. So that would default to whoever is really controlling the company or the business. Employees, if they have no ownership interest, they're not considered beneficial owners. Inheritors, so if you, your parents or your grandparents own a company and you stand to inherit it, you're not a beneficial owner until you actually own that 25% of the company. And then creditors are not beneficial owners. This one's a little more straightforward, but let's go through a couple of examples. So it's a quiz. You will not get graded on this because it can be complicated. So again, in this drawing or in this example, the reporting company is an LLC. Individual A is a manager, but they also own 50% of the membership. And then individual B owns 50% of the membership. Individual C doesn't own any of it, but it is a manager. So under our 2 rules, 25% ownership or substantial control, who is considered a beneficial owner? And I don't know if you can use emojis or if you can put it into the chat. But this one's pretty straightforward, right? Individual
You can type
A.
it into Q&A.
Oh, okay. If you want to put it into the Q&A, you can too. Give you extra points. It'll be like all three. All right, we're getting a lot of right answers. Thank you. So yes, it's all 3. A and B are beneficial owners because they own more than 25% of the business. And then A and C are beneficial owners because they exercise substantial control as the manager. And this is a situation that a lot of you who have asset protection structures are going to be in. If you think of the reporting company as your Wyoming holding entity, then that's going to be your beneficial owners. If you have a bunch of sub entities, the information is going to be exactly the same. The beneficial owners are going to be the ultimate owners that own your holding company. All right, we're going to go on to a slightly more complicated example. So reporting company is a corporation, so there's stock. Individual A owns 50% of the stock. Individual B owns 40% of the stock, and individual C owns 10% of the stock. And then D is the president. So out of these 4 individuals, who are the beneficial owners? You can put it into the Q&A. Got people saying A and B, A, B, and D, A, B, D. Don't be shy. Give us your answers. It'll be like elementary school. You could win a free personal pan pizza. I'm just kidding. We're not giving those away. Okay, A, B, and D are the correct answer. A lot of you got it correct. So individual A and B, because they own and control more than 25% of the company's stock. And then individual D, because as president, they exercise substantial control. So again, those are the 2 tests. Individual C neither exercises substantial control nor owns more than 25% of the stock. So they are not a beneficial owner. So it's just the A, B, and D's information that's going to go on your report. Okay, this one is hard. I can't even figure out who the beneficial owners on this just from looking at it because it involves math. And when you go to law school, they tell you all day, every day, you're not going to have to do math. And frankly, that's a lie because look at this. All right, so we've got a reporting company. It's a corporation, but it's owned by two other companies. So company Y, it is 30% owned by individual A, who's the CFO, and 70% owned by individual B. And then we move over to company Z. 50% of those shares are spread out between individual A, who's the CFO, individual C, who's the CEO and the president, and then D and E own 25% of the stock. On top of that, we've got individual F, who directs important decisions through board representation. So of these, 1, 2, 3, 4, 5, 6 people, 1, 2, 3, 4. Oh, okay. So individual A who owns 30% of company Y and individual A who owns 25% of company Z are the same person. Just to clarify that. I've done this example before, and that was slightly confusing. So individual A actually owns a piece of each of company Y and Z. And so if you are actually able to figure out which one of these are beneficial owners, then you are a better attorney than me, or at least better at math than me. So we've got all of someone saying all of them. We've got A, B, C, F. We've got B and F. Everyone. Some of you are just giving up and saying everyone. All of them. I'm quite impressed because several of you have gotten this correct. So the answer is A, B, C, and F. So A is the CFO. They exercise substantial control and indirectly own 27.5% of the stock of company Y. And that's because math, right? And then they also own percentage of the company stock through company Z. So those combined together, your stock from Y, your stock from Z, combines to be 27.5 of the stock of our reporting company. So individual A is a beneficial owner. B, indirectly meaning it owns 35% of the stock in the reporting company, but it's doing so through company Y. So remember, the beneficial owners are only ever going to be people. The company Y and company Z, even though they're the direct shareholders of the reporting company, they're never going to be the beneficial owner. The entity is not going to be the beneficial owner. It's always going to flow right past those to the actual individuals. So that's where the math comes in. C is a beneficial owner because they exercise substantial control as the CFO. They only own 12.5% of the stock of the reporting company. So 25% of the company Z stock equates to 12.5% of the reporting company stock. So they are not a beneficial owner based on their ownership, but because they're the CFO, they are still a beneficial owner. And then F, no ownership whatsoever, but because they direct important decisions and exercise substantial control through board representation, they are a beneficial owner there. So engineer, somebody said they're an engineer. So yep, the math part. All right, so these examples actually come directly from the FinCEN Small Business and Entity Compliance Guide. FinCEN's done a pretty good job of creating resources such as an FAQs, updating, keeping their website up to date, creating this small ownership compliance guide. There are little quizzes that you can say, if you can say yes to this and yes to this, then it's sort of a decision tree to say your company is exempt. So this is a really great resource and we can link it in the chat. Actually, let me do that. Is that okay if I link it in the chat, Don?
Oh, yes, you can get to the chat. The students,
Okay.
it's been disabled, so they can only use the Q&A. That way we don't have to watch both.
Okay.
Okay.
There you go. So everyone, if you want to click on that, that's going to be the small business compliance guide. It's long, but if you're wanting to dig in deep, if you've got one of these more complicated situations, if you think that you qualify for one of these exemptions, it's going to be a really great resource for you. All right, so we have to do this report, but I don't want to do this report. Trust me, we are all in that boat. But unfortunately, there are pretty severe penalties for failure to file. So willful failure to file or providing false or fraudulent information can result in civil penalties up to $500 a day for as long as the violation continues, or criminal penalties including up to 2 years in prison, and a fine up to $10,000. So this is pretty steep. I like to equate it to willfully not filing and paying your taxes. You eventually will end up in jail, right? How FinCEN's going to enforce this, when they're going to start enforcing this, that's still a question. I anticipate there will be a lot of leeway in the first couple of years. Europe has a very similar law, and that's been in effect about 2 or 3 years, and they're only now starting to crack down on people. That's partially because it's a little harsh to create this very complicated compliance structure and then to harshly penalize people as everyone's still getting used to using it and knowing what to do. It's also going to take FinCEN quite a bit of time to get their act together on the back end, cross-reference their reports with state filings in all 50 states, plus territories, plus Native American territories, and sort of cross-reference that material to even figure out that there's something going on. The IRS does it based on W-2s being filed and those not matching up with the filed tax return. But the IRS has been around for a lot longer and been doing their thing for a lot longer. So it is going to take FinCEN some time to rev up. So don't imagine people who are a few days late on their filing in 2024 are going to be harshly penalized, but you should be aware of the penalties because they can be pretty steep. There is a 90-day safe harbor. So a safe harbor means that if you file a report and you realize that you made a mistake or there was something inaccurate and you file an updated report within 90 days, then they basically give you a freebie, right? A do not go to jail card, get out of jail free card, essentially. So you do have the opportunity to update it to be like, oh, sorry, I had a typo, I made a mistake. I work with a partner and they gave me the wrong address. I'm going to update it. So you do have a safe harbor. But again, penalties can be very steep. So we do want to make sure that we're on top of this. Finally, essential provisions. So at Anderson, we set up entities. These are the steps and the things that we're taking, that we're doing for clients, for new entities, for existing entities, to make sure that it's compliant with the Corporate Transparency Act. So we've updated our operating agreements. We've included language in any operating agreement, bylaws, statutory trust agreement that will potentially have to adhere to the Corporate Transparency Act. And we've created clauses that essentially protect all of the people involved. So if you're the only owner of your business or you and your spouse are the only owner, you're not really worried about not providing your identifying information to yourself. Obviously, you have it. Obviously, you're going to be able to file your report. We're talking about when you're working with third parties. Maybe you've gone out and you're doing a flip. So you found another investor that you networked with and you met at a conference. And now you're having to set up the entity and you need to get their photo ID and they're just being really resistant to it. So we've incorporated this into the operating agreements and bylaws such that if one of the owners, if somebody who qualifies as a beneficial owner refuses to provide their information to the company and thus ends up the company filing the report late or not filing at all, that all of the liability is going to shift to that partner, that they'll be personally liable for any fines, and it'll essentially indemnify the partners that are not involved with the lateness. Failure to report any changes. So if your partner moves and they don't update you on their address, then you can't be held responsible for then not being able to update the beneficial owner report. What this does is it makes it really, really important when you're getting into business with somebody that you don't know very well, that's not a family friend or somebody you're related to, or it's going to make it really important to be very, very clear up front that you need to be able to provide this information to each other. It would be good to have one person be in charge of the filing, and so they're kind of become the resident expert in it. But all that information has to make it onto one report. There isn't a way for individuals to report their own information. If you have a partner who is resistant to providing you a copy of their ID, or if you don't want to provide a copy of your ID to somebody else, then go ahead and apply for that FinCEN ID. That's going to be you logging in, creating an account, providing all your info to the government. They spit out that ID, and then all you have to do is hand that ID out to everybody who you're partnering with. So number 1 through 4 are going to be things that we're adding to our binder agreements, trust documents for all new entities. And we started that last year. So if you've gotten an entity from Andersen, you can check your operating agreement, see if that's there. If it's a PDF, I just do Control F and look for Corporate Transparency Act, and it should pop up that info. If you have an older operating agreement, or if you've got an existing entity, what we've done is we've created templates for meeting minutes and for company resolutions. So as a platinum member with Andersen, you have access to our forms library. We'll draft meeting minutes and resolutions for you, send them to you via DocuSign. Those get incorporated. Any signed resolution gets incorporated to your operating agreement and is essentially an update, so that you don't have to re-update your entire thing. You essentially just attach it on. So what you'll do is you'll hold a meeting with all of the partners. Again, if that's just you and your spouse, or that's just you, that's fine. But if you do have third parties, you want to include them. Everyone votes, everyone agrees, and then it gets in, you sign the meeting minutes, you sign the resolution, and that gets incorporated into your existing operating agreement and becomes essentially the law of your company. And then for those of you who are working with Andersen or doing that, there'll be a lot of notifications that pop up. If you change your contact information, you'll get a notification that says, hey, it looks like you changed your address. This could potentially mean that you need to file an updated beneficial ownership information report. Please go here, or please call here for more information. What can you do now? The biggest challenge with this is if you're working with third parties. And obviously, like I said, it's because there's a lot of sensitive information. The information FinCEN's asking for is essentially everything you need to steal somebody's identity, right? So a lot of people are resistant to handing that over to people. So the biggest challenge will be obtaining that information from your third-party partners. So if you have an existing entity, you do have until the end of the year. Start now, start educating each other on what you need, the importance of why you need it. $500 a day fine and possible jail tend to be really big motivators for people. But you want to get that information now. You want to identify which of your entities are reporting companies. Do they fall under an exemption? Is it a nonprofit? No, that one doesn't have to file. If your company has more than 20 employees, it doesn't have to file. So start creating the list and compiling all of the information for your reporting companies, whether or not it's exempt. And then for each company, identify the beneficial owners. People who own 25% or more. People who exercise substantial control. For most of you, that's going to be just yourselves. So it's going to be pretty easy. But for those of you who are very diversified, who maybe run active businesses while also doing other investing, it can get more complicated. Doing a lot of partnerships, you can have a lot of beneficial owners. And then determine if any of those owners are exempt. That's mostly going to be if you've added your kids, but that's going to be the big exemption for whether a 25% owner doesn't have to report, but any nominee, any employees, they don't have to put their names down. And then start collecting that required info. We're at the end, and we're about to get crazy with the questions, everyone. Here's our link. If you want a free strategy session with Andersen, you can get one. We have business advisors, senior strategists. We set up asset protection structures. We can talk about tax. And as part of that, we can definitely talk about the Corporate Transparency Act. We do have this great resource which I will throw into the chat if that's possible. I call it the CTA Hub. It features our fearless leader, Clint Coons, and it basically has everything that you need to know about the Corporate Transparency Act. There are videos, there are PDFs that you can download, but it's a wealth of information. I'm in charge of updating that. I know that there was recent new regs that came out on the 6th. We're still combing through those and making the necessary updates, but any updates that are necessary will need to be added to that as well. But that's a great resource as well. Don?
Okay, let's start with questions. And we're going to go, and there's going to be some redundancy. I'm going to try to cut some of those out. Who has oversight over FinCEN to make sure that they're following the rules?
It's the U.S. Department of the Treasury. So it's basically under the president. So we have 3 branches of government, the Supreme Court, the judiciary, which is the court system, Congress, and then the president. The president runs all of the federal agencies. But it's the U.S. Department of Treasury.
And how is the information to be used? I mean, who has access to it? What happened to anonymity? I don't know, all that. Yeah.
Yeah, anonymity is a big question. So when we talk about anonymity, we are trying to keep your name off the public record. So deeds are public record. Secretary of State filings are public record. So you'll still have anonymity in that sense. All of this info is going directly to FinCEN. So it's similar to how you have a tax return. That goes directly to the IRS. Does it have identifying information? 100%. But can just any Joe on the internet find it? No, it's private, right? So there will be some cross-departmental opportunity because the whole purpose is to find bad actors. So there will be an element of law enforcement who will be able to access the information under certain circumstances, but it's not going to be anyone with the general public. If somebody sues you, it's very unlikely that they're going to be authorized to pull the information from FinCEN when they can obtain similar or the exact same information through the normal court discovery process. So it's not like just anyone can file a Freedom of Information Act and grab your info. It's not going to be like that. It's going to be the FBI has, or the state district attorney has X amount of evidence already built up, and then they can request or subpoena the information from FinCEN. So it's a very limited group of authorized agencies, and the rules as to what it's going to take to access this info, even by those agencies, has not been solidified whatsoever.
So right now, it's really specific to law enforcement agencies and financial information or institutions with your permission, right?
Right. So
do you see this where a bank won't give you a loan without you submitting to give that information?
Well,
or they won't open a bank account?
Sure. I mean, this information you're already giving a bank to open a bank account. You're not walking into a bank saying, give me an account and not providing your ID, not providing an address, not providing your name. So a bank or a lender is not going to need to go to FinCEN to obtain this information because you're already giving it to them. Will there be on the back end some cross-referencing to make sure that the beneficial owner on the entity is the person who's opening the bank account? Most likely, because when those things are not matching up, that's where they're going to find the fraud and the discrepancies and the money laundering. So as people running legitimate businesses, you're not going to have to worry about that. You're the beneficial owner of your company. You're providing your personal information to FinCEN. You're opening a bank account for your completely legitimate company. You're providing that same information to the bank. That's going to match up. That's not going to raise any sort of red flag and have anyone coming after you.
Okay, perfect. All right. I opened a California LLC and Wyoming both in 2023 and closed both of them in 2023. Do I still need to report?
Yeah, so this was the weird rule regarding an inactive entity. And the first of the 6-part test is, was your entity created prior to January 1, 2020? You have to be able to answer yes to all 6 questions. But if your business was created in 2023, you actually answer no to that question. Was it in existence January 1, 2020 or before? No. So automatically it doesn't qualify for that exemption. Is that a ridiculous result? 100% to have to report info for an entity that you created and then close down within 1 year. But that's the way the current rule reads. And there hasn't been any clarity or confirmation that that's not the case. So in an abundance of caution, we are counseling clients to file an initial report for those entities.
So if I close down, I've got several entities, and I closed the ones that I've probably been delaying this way too long. I closed them down now. I still ought to report those. Is that what you're saying?
If they were created after January 1, 2020.
Okay.
If they were created before that, so if they're old, super old, then you potentially don't have to report.
Cool. All right.
The best thing to do if you are wondering if you qualify for the inactive entity exemption is to go to that CTA hub, print out the PDF that lists the exemptions. It'll show you all 6 things. And if you can answer yes to each one, then you don't have to report. If you answer no to even one, then you do.
Cool. And if I have questions, I can go to this protectwealth.com and ask for a consultation. Ah, there we go. Okay, that's good. So unlike a tax return that requires an annual filing, this is just a one-time thing unless there's a change of address, change in member status, shareholder, unless there's a change. Is that correct?
Correct. 100% correct. So if the ownership changes and a new owner owns 25%, if a minor who owned 25% turns 18, if you get divorced, change your name, get married, change your name, move, your ID expires. There's a lot of ways that will trigger an updated report. But if none of that info changes, if none of your personal info changes, then you don't have to ever update it. It's not an annual requirement.
Okay. Registered agents don't have to apply. I think you covered that very well.
Correct. So you cannot use the registered agent address, unless that's the company's principal place of business. Most of the time it's not. You want to use for the company, the principal place of business, and for the individuals, it needs to be their home, their primary residence.
I think it's the same if my LLC is being held inside of a self-directed IRA. Do I also need my custodian as a beneficiary? Do I have to file that? It's a disregarded entity to the self-directed IRA. Do I have to file information on that?
Yes. So you do have to file if it's self-directed. Your custodian is sort of only doing what you tell them to do, or you're sometimes your own custodian. So you're still reporting your own info. If the custodian has substantial control, so they can sort of do things sua sponte or on their own, then you'd have to report their info. But most self-directed IRAs are not set up like that. You're self-directing them. That's sort of the definition of a self-directed IRA. So you're not going to have to report that like corporate custodian. They're really more of an admin person. They're not controlling the LLC itself.
Okay. Driver's license, not passport?
Either.
It would be one or the other, right?
One or the other. Government issued ID.
Okay, good. Can the address be a resident agent? No, I think we covered that. No. Is this for LLCs, S corps, C corps, or sole proprietorships? No, sole proprietorships don't have to file with any Secretary of State, do they?
Correct. So a reporting company has to be created by filing documents with the Secretary of State.
What about a DBA? Because that is filed with a Secretary of State.
Sometimes. So the DBA doesn't create the entity. It just gives it an alternative name. It's where the entity is created.
Okay. Can you use your virtual agent address versus your personal residence?
Nope. It has to be your personal residence.
Very nice try.
Nice try.
Is it legal to use a military ID? I think you've covered. Oh, you said you didn't know.
Yeah, there is, they haven't specifically said no. They said a government issued ID, passport, or driver's license, but military ID does fall within government issued. So we're telling people we can try to submit with a military ID, but if you do have access to your passport or your driver's license, that's better. I know that's hard if you're deployed. Um, we have an employee here that was asking that exact same question. Unfortunately, there's not a black and white answer on that.
And no, we don't have to keep. It's a one-time thing. Don't do it every year. What do you need to do if you dissolve an entity? I think you've covered that lots, but one more time to
Yeah, it
dissolve it.
depends on if it was created before January 1, 2020 or not. If it's before January 1, 2020, it can potentially qualify for the inactive entity exemption, but it has to have not done any business for 12 months, for a year. If it was created 2020 on, then it's still going to have to file an initial report, even if it's dissolved.
Okay, Tim, is there a requirement that we retain any documentation associated with the BOI report process?
No, there's no requirement, but just like filing your tax returns and keeping them around, you want to hold on to that confirmation page. You want to hold on to all the underlying information.
I think it would make sense, especially if there's a penalty. Yes, I did submit it, but there are right now, I understand they're not confirming that they've received the information. Is that correct?
No, you should get a confirmation. It says they say you should get a confirmation right away.
Okay, good. Do I do I need to report an entity being dissolved? I think we answered that. Um,
So I think that's a slightly different question. Whether a dissolved entity needs to report, potentially yes, but do you report when the entity is dissolved? No, you do not. So you only file an updated report when the information changes, like the address, your name, your beneficial owner, or your entity information changes. If your entity is not exempt and then becomes exempt, you just stop reporting. You don't notify them and say, hey, we're exempt now, we're not going to report anymore. You just stop reporting.
okay, now we're only down to 59 questions. They keep growing. We're going backwards, Amanda. Okay. Is there an LLC created for holding precious metals within a self-directed IRA? Is it a reporting company?
Yes.
Yep. For number 13, state issued insurance producer. Does that mean an insurance agent, or does that mean or company that happens to sell the insurance?
I'm not sure exactly. And I can look that up in the small entity compliance guide is going to have more details on that one. We don't work with any clients who really are going to qualify for that. So I would default to, if I'm an insurance agent, am I providing that information to a government entity already? If you are, then most likely you would fall into that exemption. If you're not, then it doesn't qualify there. But we can look into the small business compliance guide and get a more detailed description. I just don't know that one off the top of my head because we don't work with a lot of insurance producers. It's
And we're
likely going to be
asking,
like the big companies, though.
and most of the questions we're answering right now were created before you were done with your presentation. So I'm sorry.
No
Thank you
faith.
for your
You guys
patience.
have no faith in me.
For number 13, we did that. What qualifies as inactive?
That's the 6-part test.
And where do they find the 6-part test?
So you can find it in the small entity compliance guide. There's going to be like a little quiz. You can find it on our CTA hub. There's a list of exemptions that you can even pop out as a PDF and print. So any of those 2 links I provided.
Ooh, good question, Mohammed. I have a Texas Series LLC. Does every cell have to report?
So Texas series LLCs were a little tricky. We had to actually think about these pretty hard because you do file a DBA with the state in Texas for some series LLCs. The issue is that DBA isn't what creates the entity. So cells are not created by filing documents with the state. They're created by executing the cell agreement off of the operating agreement. So no, series cells do not have to report.
But would that change in a different state?
It might. So if the cell is created by filing documents with the state, then it would have to report. But if it's merely created by sort of an additional document that's attached to your operating agreement, then it doesn't. So the way that we do series cells is you have the main operating agreement, and then there's just a smaller one page saying, I create this series cell on this date, and it's signed. And so it's
But that's
created through that one page document. And then
but
most
that
of them are never filed.
right. It's an internal document not filed with the Secretary of State, and that seems to be the the main discussion point
Right.
is, was it filed with the state agency?
Yeah.
Your
Was it
living trust,
filed?
a land
And
trust was not.
right. Was it filed? And is that filing what created the entity?
Great. If this is for talk about you know what, Clover, good question. Let's talk about anonymity for a second. You guys are very good about creating anonymity. If somebody creates, let's say a Wyoming LLC, and they use you as a nominee officer, and their name is not on any public record, but the federal government knows. Have they lost any anonymity?
Not really, because when we talk about anonymity, we're talking about keeping yourself hidden from the general public. You can't keep yourself hidden from the federal government. You're not keeping yourself hidden from your bank. You're not keeping yourself hidden from a lender or taxing authorities. Those are never the third parties that we were trying to hide from. We're trying to keep yourself hidden from the general public. And since this information isn't going to be just Googleable, then you still have your anonymity. Somebody who rents from you, who wants to look up who owns the property and look up who owns this entity, is still not going to be able to find you listed on anything.
And when the government really wants to keep it secret, they're actually pretty good at it. You know, who
Until they
killed
need a distraction,
JFK?
right?
Yeah, is there an Area 51? I don't know. When they want to keep the information, they're. What did Donald Trump pay in his taxes? I don't know. It's pretty hard to get that information if we wanted it. I don't, Clover. I don't see that as being a problem right now, unless the government expands and says, okay, now this database is open to more people, and there's a lot of theories out there that that was their intent. But
Yeah, I find I still don't think it's going to be open to the general public just because of for identification issues. Like if this becomes open to the general public, anyone could steal anyone's ID. Like identity theft would just run rampant. So they can't really be offering this up to anyone.
and the government already has your passport number, and they already have your driver's license number, and they have your social security number, and they have your address because it's on your tax return.
Yeah.
We're not. Yeah. Okay. Got it.
We got the
They.
tracking in your arm too, if you got the shot too, right? Wasn't that the thing too?
There we
I mean,
go.
we walk around with these. The government's going to know where you are.
There we go. Homeowners Assurance Association in the state of California, registered as a non-for-profit California corporation, is a tax-exempt entity. Is that correct?
Yep. If it's registered as a 501c3, it is. It's exempt under the tax exempt entity.
Okay. What about Anderson Trading Structure, which consists of managing C Corp, which with a partner LLC brokerage account? Yes, they would have to report.
Yeah. So in that structure, we've got one reporting company as the corporation and one reporting company as the partnership. But ultimately, you own both of them. So your information, you're the beneficial owner for both of them. So two reports, but only your information on both reports.
In the example, one owners have to report for the corporation for companies X or Z, so they have to file two reports.
Yeah. So let me actually go back to that visual. Oh, passed it.
Right.
Okay. So here, the example was with this top company as the reporting company. But in reality, company Y and company Z are also going to have to file their own reports. And for each of those, company Y, individual A and B are going to both be beneficial owners. And for company Z, all four, A, C, D, and E are going to be beneficial owners. So in this example, there's actually 3 reports happening. We were just running through who the owners would be for this top company.
Perfect. Okay. Again, about disregarded entities. Disregarded, do they have a disregarded LLC? Do they have to file?
Yep. It does. The tax status of the entity is not relevant.
Okay. What is a company applicant?
Yes. So the company applicant is the person who submits the documents to the state to create it. So at Anderson, that's going to be our entity processing team. If you go to a small law firm, it's likely going to be the paralegal. If you're doing it yourself, it's going to be yourself. So it's going to be whoever is physically clicking that button or sealing that envelope to send the documents to the state for it to be recorded.
Whether they have anything to do with the entity or not, they're the one filling out the report.
Right. And the reason they're doing that is because they want to find the service providers who are setting up fraudulent entities. So if they find one money laundering scheme over here and they start to see the same company applicant on a bunch of different companies, then that can result in them looking more closely at those. So we're not only catching the bad actors, we're catching the people who are facilitating the bad actors.
Okay. Again, a series LLC, lots of cells, child, do each one of them have to report? And I think we decided that depends on the state. And if the cell was created by filing an application with the Secretary of State.
Right. I don't think there's a state where you have to file for the cells. So most cells we're not filing for. We are filing a report for the company, for the holding company, and for the parent LLC, but not for the cells.
So if you had an LLC after 2022, but it dissolved before 24, once you file the initial report, do you have to provide updates?
That is a tricky one. So this is why I say that this inactive entity exemption rule just results in a ridiculous response. Like it comes to a ridiculous result because technically you do have to file an updated report if you move, if you change your name, even though that entity's been dissolved. So because this is kind of a moving target, I mean, somebody in the chat even pointed out that new regulations and FAQs were released last week. We are advising people file that initial report. You don't want to get dinged for not filing the report with the hope that they will come out with additional rules to say if the entity is dissolved, then you no longer have to update it.
So Carrie, hold on to that question. That's a
Right.
really good question, but to be continued. Okay, we're getting rid of that. Barbara, thank you for being on. Amanda mentioned something about companies created after 2020, but I didn't catch it. Tell me one more time.
That's what we were just talking about, Barb. So if your entity is created after 2020 on, even if it's dissolved, it doesn't technically qualify for the inactive entity exemption. So we advise you to file that initial report. We're hoping, fingers crossed, that FinCEN comes out with a regulation saying if you dissolve it, if it meets all these other criteria, doesn't do any activity, then you no longer have to update it.
And Claude, really good luck on this one. Can we hold the government responsible if there's a data leak? Well,
I mean, we can't even hold individual companies responsible for that. Maybe there'll be a class action and you'll get $3.
Yeah, good luck. Yeah, I don't know what to tell you on that. So we need to update our FinCEN reports for all open and closed LLCs even when our driver's license expires.
Yep, because the expiration date's one of those things, the photo of it. So when you get a new ID, you need to upload a new photo of it. I know, Calvin, trust me. We're here. This is a huge burden on people, on small business owners.
But
Just
I
hire 20
digress.
employees and pay them full time, and then you don't have to report anymore.
The only way out maybe death. Do you have to report death? And what are they going
No,
to do?
I guess your address changes, you put the plot, you put the address of your earn.
Okay, Miguel, what does it cost if Anderson files the CTA report for us? Okay, now we're getting somewhere. Good. Okay, this is good. You
Yeah.
didn't get to that, so thank you.
Yeah. So if you're an existing client, we're going to be reaching out to clients who have set up entities through us. We're going to start reaching out to you in Q2. The reason we're waiting that long is because, as you can tell, things keep changing. So we don't want to reach out to thousands of clients and then have to switch things up. So we're sort of waiting for the dust to settle a little bit. We'll reach out to you through email campaigns, things like that. And we'll file your, if your entity is active with us and we're your registered agent, we're servicing your entity, we'll file that initial report for free. All new entities we're setting up, we're also filing that report for free because for employee confidentiality reasons, their information is attached to that report. So we're not going to be just handing that out to everyone. So we're filing that initial report for you. We do impose some timelines. So if you don't get the info to us within a timely manner and there's specific dates, then we're charged up to $100. So if you have an entity, we're not servicing it, but you still want us to do the report, we'll do it. It's just going to cost $100 per report.
Cool. All right, I was the executor of my dad's trust when he passed away. Do I need to file with FinCEN? Okay, was the trust created by filing a document with the Secretary of State? Alvin, no. What about a revocable living trust? No. Okay. Al, you know these things. Okay, so call us if you have questions. Or will you put up your screen one more time if they want to consult?
Yeah, let me go back to that slide.
And here's where I think it's really important. If she hit one of those exemptions and you think you're exempt, I would, because of the penalties, I would get a free consult and just make sure. It's well, it was listed as number 16. You better make sure because you don't want to miss that. You don't want to misinterpret these exemptions. Any thoughts on that, Amanda?
Yeah, 100%. I mean, we have our whole team of platinum attorneys. If you're a platinum client with us, you get unlimited access to our attorney team. We've started this new, it's kind of a cool feature. It's the Platinum Knowledge Room. So from 9 a.m. to 2 p.m. every single day, you can jump into a Zoom call and there's going to be multiple attorneys in there answering whatever question you need. So you can pop in, you can say, hey, this is my situation. You can get a breakout room and just talk one-on-one with the attorney. They can look up your info. They can advise you as to whether you need to the report, and we can start on that report for you.
I didn't know you did that. That's really
It's
cool.
pretty new. The Platinum Attorney Access has evolved. So when I started, you had to schedule meetings with attorneys, and then we
Yeah.
would have clients schedule like meetings well into the future and then never show up. So we switched to more of a call-in situation, and it was a hotline, so you could call in and an attorney would answer and say, hey, what do you want to talk about? But now we're doing a Zoom call and it's actually kind of fun. The if you guys don't come in and ask us questions, the attorneys just start talking about all kinds of random stuff. I have learned things about some of our attorneys that I did not need to know because we need more people to come in and ask us questions. But we have tax people in there. We have everyone on our back end fulfillment side. So if you want to have an update on something like, hey, did you get my SS4? What's the status of my EIN letter? All of the things that you need answered, you can come to this one spot and get access to almost anyone.
Cool. I did not know you did that.
Yeah.
That's really cool. All right. David, I assume, is asking questions about a land trust. If the beneficial owners change during the year, do you have to report it? David, the land trust wasn't filed with the state agency. Does that
Oh, so
answer the
the
question?
right. So land trusts definitely don't have to do a report, but the beneficial owners, if you have an entity and and the beneficial owners change, then you do have to file an updated report. So if you have an existing entity, remember that was created before this year, remember you have the whole year to file. So if you anticipate anything changing kind of throughout this year, you want to wait till you're settled to file that report. Because if you file now and you change things 3 more times throughout the year, you're going to have to file another report and another report and another report. So if you have a pre-existing entity and you anticipate like bringing in a new member, or you think you're going to move, we've had clients say, hey, can you hold on filing my initial report because I plan to move in the next month and I don't want to have to go turn around right back around and file an update.
Okay, good. All right. Who's responsible for creating this? I'm not sure what he's asking. Do you know?
Congress?
Oh, the law?
I
Yeah.
don't know. I don't know. John, it's
Well, and
Congress.
remember that this
Everyone
was
vote.
signed by 81 senators, so it was very bipartisan. And I really think that they're trying to cut down on some illegal activities that maybe they know about that we don't. And I don't know what went on behind the scenes. It was created and then it was vetoed by Trump, but it was vetoed because it had so much garbage on social media stuff in there. I'm not sure why Trump vetoed it, and then Congress overrode the veto, but it's effective now, and so it is the law whether we like it or not. And we already talked about Almo, how they deal with Anderson's clients. Information will only be available to law enforcement agencies and financial. I thought there were fines to be expected. Consent is meaningless, is it not? I don't know how to answer that one.
Well, you're technically consenting to the reporting by opting to do business in the United States. That's the legal argument as to why you want to avail yourself of the business landscape in the United States. You need to comply with the laws of the land. So,
Can a new administration overturn this?
sure. It would likely take, so the presidency, runs the agencies like the federal agencies. So the direction to not enforce it as strictly as possible, like to the least extent possible based on the law, could come from the top, right? Like
Sure.
you can have an executive order that says we want to, like the EPA. Trump says we want to focus on this or not focus on this, or we don't care about this. As long as it falls within the congressional rule, the executive branch can do that. But in order to completely overturn the law, it would have to be an act of Congress, or somebody would have to sue and the Supreme Court would have to overturn it, but that's really unlikely to happen.
Okay, that was good. Revocable living trusts in Arizona, they're not filed with the state agency. Does a living trust need your social security number need to file? I think we answered that. Wow, I need to, okay. Does CTA apply to ownership of foreign
Foreign
companies?
companies, only if those companies are registered to do business in the United States.
Okay, good. What if your company was administratively dissolved but not terminated? Is it still required to report?
It's going to go back to that inactive entity exemption. So if it's created before 2020, likely no. If it was created after 2020, yes.
So private and public charities are exempt?
Correct. So those are nonprofits under 501c3. Nonprofits and their subsidiaries do not have to report.
And if you have questions, get a consult and make sure. If I open an entity with two others in 2020, then change the entity to one owner, then close the entity in 2022, I assume I need to report two reports. First with the three owners, then one with the one owner. Look at Carl's.
No. So even the report, your initial report is going to be what the reality of your company is at the time of the report. So if you created it in 2020 and a bunch of things have changed since then, you had 3 owners, now you have 1 owner, now you have 2 owners. Your initial report is going to report the current status of the LLC, the current beneficial owners. If after that initial report something changes, then you'll file an update. But if things have changed previously, they're not asking us who were all of the shareholders and beneficial owners for the last 20, 30 years. They're not asking us that. There's like who currently owns and controls the company.
Okay. For a California non-for-profit where volunteers control the operation of the entity, are they required to file?
Nonprofits don't have to file.
There we go.
So step 1 is to figure out if your company has to report. Step 2 is then to figure out who the beneficial owners are.
Man, I'm sorry. We were asking the same
No,
question
these are all
30
great
different times,
questions,
but
and this is a confusing law, and there are not a lot of black and white answers when you start getting down to individual situations.
and so here we are going to answer as many questions as we can before 8 o'clock, and then Amanda has 6 kids at home, and we're going to send her. We're going to release her with a vote of thanks for a job well done, and let her go, and encourage you to get a consult if you still have questions. Okay, would you put in the website the place if they want to do it themselves? Graciela wants to do it herself. Where would you file yourself?
Yeah, so I just put it into chat. It's fincen.gov/BOI. Boy, I always laugh because BOI sounds like boy, like if you're doing a hip hop dance. So you could click there. You can file by paper. You can file online. So you could print it out on paper, mail it in. You could do it online. And you can create your FinCEN ID from that link as well.
Perfect. I have a corporation formed in the state. It has never been active. I just keep the name, but never have done any business under this name. It has no bank account or any employees. Do I have to file?
If it was created before January 1, 2020, no. If it was created after January 1, 2020, yes. So people think your entity not being active means that you're not conducting any business. And that's not necessarily true. It's not conducting business, but at the state level, it is active. So it still exists. So they're not looking for, FinCEN's looking for the existence of entities. I think they're saying how and with who do we file this report?
Oh, I got it. Okay.
Yeah.
And I think you just gave that link.
Yeah, so that link is in the chat. You can go directly to that site. If it's an existing entity, you're just giving your info. You don't have to provide a company applicant info. So if you set up your business 20 years ago, you're not having to track down the attorney and the paralegal who set that up, if they're even still around. You're just reporting beneficial owner info. If an entity is brand new for 2024, then you're most likely going to have to let the company who set it up for you file it. That's what we're doing at Anderson because of employee confidentiality. We can't provide our employees' information like ID to people on the internet. We love you, but we don't know you. So you're likely, if you're having a law firm or like Anderson set it up, then we're doing that filing for you.
And remember, if Anderson's already your attorneys, they're taking care of this for you, and there's no additional charge. They're your resident agent. If they're not, then she's offered you one heck of a good deal to file this for you. So, I'd take advantage of that consult. Okay. What about a 508c1a? Is that considered exempt for this purpose?
No. So I'll give you the actual. Give me 1 second. The actual code sections that qualify for 501c. So it's 501c 527e1 or 4947a1 or 2. So those are the exempt entities. And again, that's on our CTA hub. You can find the list of entities. It's going to list those same statutes there.
Okay, good. All right. Is a self-directed Roth considered an entity?
No, because those aren't created by filing documents with the state. But if you have an LLC owned by that Roth, then the LLC is a reporting company.
Got it. I have 4 LLCs created prior to 2020, so I don't need to do any reporting, correct?
Only if they qualify for the other 6 parts, the other 5 parts of the inactive entity test. So they're created prior to 2020, so we can say yes to that. Are they not engaged in any active business? Yes or no? Are they owned by a foreign person? Has there been a change of ownership in the preceding 12 months? And I put these 6 things in the chat. So if you can say yes to all 6 of those things, then you qualify for the exemption and you don't have to report. If you say no to even one of those things, then you don't qualify for the exemption and you have to report.
So if this is still an active business, yes, you do have to report.
Yeah, if
So
you're actively conducting business, then you do.
So what my concern is some of you are asking questions because you heard one little piece, and you don't decide whether you're exempt or not because of what you think you heard. Really, go to the information that they're provided, that Amanda's provided, or it's a free consultation, for heaven's sakes. Ask the questions. We honestly cannot make it any easier for you. Amanda, we got just a couple more minutes left.
Sure.
Are there any questions here because we're not going to get to all 110 left. I'm a foreigner. How does this work?
Even if you're a foreign person, if you qualify as a beneficial owner of a company, then you do have to list your information. So if you own an entity created in the United States, or if you have a foreign company that's registered to do business in the United States, you're still obligated to comply. And that's what I said earlier in terms of consent. Like, you're behooving yourself of the United States economy, so you have to comply with the rules of the law of the land.
And Heidi, I think that answers your question. You're a beneficial owner of a U.S. entity, but you live outside the U.S. Yes.
Yeah, we have a ton of clients who are either Canadian, there's a lot of Chinese real estate investors. They all need to provide their information to comply with this if they're going to have a business entity.
I have one LLC that created in 2020 and dissolved in 2023, so I don't have to report either one. Read the 6 questions. What else do you see there?
A lot of them we already answered. So.
I think so. What about attorneys? Do they have to report?
If they're the ones if they own an entity, they have to report for their own entity. They don't qualify for an exemption. If they are creating the entity for you, they could potentially be the company applicant. Most of the time, even in a traditional, like, small office law firm, the company applicant's likely going to be like a paralegal or administrative person. The attorney will prepare the documents, but the company applicant is the person who submits the documents to the state, not necessarily who completes them. So
But
you
if
can
you're
have
an
up to 2
attorney and an
company applicants.
employee, yeah, if you're simply an employee of a law firm,
Your
then
my info is not going to be on Anderson's report. Anderson doesn't have to report. We have more than 20 employees.
oh, come on, Amanda, I want to see your photo.
You want to see my photo ID?
Students, we are over time. We so appreciate you being here. We did not get to all your questions, and really as a courtesy and a thank you to Amanda, we are going to let her go. Amanda, I cannot thank you enough. But
You're
students,
welcome.
please.
Of course.
Oh,
Thank
and
you
you're
so
getting
much.
some hearts and claps and mine as well. Students, please take advantage of that. This is not we're we're trying to provide as much information as we can, but in a general setting, it's really, really hard. Take advantage of that consultation if you can. Amanda, any closing thoughts before we leave tonight?
Not really. I mean, I am 100% on the same page with you guys. This has been very confusing, so we've tried our best to provide as much information as possible. Our internal employees are very well versed. Our attorney team, we've all become experts because of this. This is probably the one federal law that we all know inside and out. And we're hoping that as we move on, there's a lot of this gray area will be um, there you go. Sorry, I didn't hit send on that last one. Those are the 6 exemptions. I had cut and paste them and I never hit send. We're hoping that FinCEN will continue to release regulations and we'll be updating our CTA hub accordingly.
And this is being recorded again. And so we will send it out to everyone who registered, whether you attended or not. But I'm assuming if you're listening, you're attending. We're going to send it out. And so you're welcome to share it with whoever you would like to share it with. Amanda, I've attended at least a dozen of these continuing education classes on the CTA, and it is still confusing. But I think you added more clarity than anyone else has.
Oh, thank you.
So thank you for being here.
Thank you. It makes the dreaming about this every night for the last 4 months worthwhile, I guess. So you're welcome.
All right. And everyone else, we will cover a little bit more when we get to the summit in 3 weeks. So it's March 4th, 5th, and 6th. You haven't signed up, but sign up for a consultation. Thank you, Amanda. And thank you, students, for being here. Have a great night. Good night.
Night, everyone.